How are you?
Hey, what's new?
I have an off docket, is that okay?
No problem.
Okay. The cause number is 255-2517. This is for Brandon Brown.
Okay.
I am not his counsel on the misdemeanor case. I'm his counsel on the felony case. I was informed from misdemeanor counsel that we wanted to put him on the docket. He's on the docket Monday here because he didn't have a felony bond. And so,
We want to, no, I think that
right? Okay.
we wanted to,
All right, pause here because this is a textbook example of courtroom confusion. Notice how both attorneys are trying to figure out the bond situation, like they're untangling last year's Christmas lights. This happens more than you think. Multiple cases, multiple bonds, multiple courts, and suddenly nobody knows which judge is holding the key. Quick question for y'all. Do you think defendants fully understand how complicated their case web gets? Or is this system confusing even for the pros?
Like figure out what was happening in felony.
and here, because he just picked up a new case. He's on bond for at least one case with us. So we're going to put it to speak about his bond situation. That's
Yeah, so I just came back from felony. I was appointed on Tuesday. He did not receive a bond that day because he was on a parole hold. And then that,
parole hold now.
no, it was lifted that same day that I was appointed. And we couldn't tell because, I don't know if you remember on Tuesday, like all the defense attorneys were kind of locked out of the internet and I couldn't check. So anyway, parole hold's lifted. And so on Monday, we put him on for Monday in felony to get a bond there and probably, hopefully resolve it that same day because the case is old.
Oh,
Yeah, it's from 2023.
right.
So just wanted to make misdemeanor aware,
Is that going to swallow this one up too, you think?
possibly, possibly.
Get the cost number?
Yes,
Is there a global offer?
there is no global offer, Judge. So he's got the 3 misdemeanors here and the one,
He has two.
He has two.
He
But
has
You see.
2 evadings and a PON, from what
I got no PC, I think. Or is it still open? Have you guys not?
it was discharged, no PC. It's not dismissed yet, Judge.
It's not dismissed. Okay. So yes, technically, I mean, well, there's nothing that I can do with that. I mean, that's right.
Right.
So,
So just wanted to make the court aware. I don't know if y'all want to put him for Tuesday.
okay. I have to let Ms. Strong know too. I don't, are we expecting?
I emailed her.
Mr. Smart here?
I think he came up with just
Okay,
yeah, he's back there.
okay. So I don't know, maybe we'll see her. But yeah, we'll put it on Tuesday. That's fine.
Okay. And then if we resolve it Monday, we resolve it Monday.
Okay, did you get the cost number?
I can tomorrow.
No, we're talking about, I was just curious about Mr. Smart.
Oh,
Let me give you the cost number. You ready?
okay.
It's 255-2517. And then there's 2 cases for you to move.
2517?
Yeah.
Okay, what are we doing?
Just on Tuesday, 3-4. Both cases, please. Okay?
That's all I have, Judge. It was good to see you.
You too?
I just put 2 bond petitions in here just now.
Okay. Mr. Butler, I was thinking Mr. Dixon for a second, but
Thanks. I have Mr. Flynn on the docket this morning for arraignment.
okay, you ready?
Yeah, Mr. Flynn?
Flynn. Oh, Flynn.
Yeah, yeah.
Flynn, yeah. Good morning, Mr. Finn. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On February 22nd, 2025, at approximately 11:07 p.m., an officer was dispatched to 59 Northeast Cross Timbers on City Street. The officer observed a vehicle run a red light, take the exit, swerving in and out of lane number 2 and cross 3 lanes of traffic, almost striking a guardrail. A traffic stop was initiated. The officer observed the driver to have bloodshot eyes, slurred speech, and the strong odor of alcohol.
6 out of 6 clues on H. 5 out of 8 on the walk and turn. This officer basically collected the whole bingo card. And look at the breath results, 141 and .138. That's almost double the legal limit. Judges don't ignore that, especially when the driver nearly hit a guardrail. Quick thought for the viewers. Should breath test numbers alone be enough to decide guilt, or should behavior on camera matter more?
On his breath. The officer had the driver and the passenger exit the motor vehicle. The driver consented to SFSTs and the defendant performed them. 6 out of 6 clues were observed on the HGN. 5 out of 8 clues were observed on the walk-in turn. 3 out of 4 clues observed on the one-leg stand. The defendant was read the DIC and consented to provide a breath specimen. The results were 0.141 and 0.138. The defendant advised he had 1 drink while at a bar and he was the owner of the vehicle and he was identified by his Texas driver's license.
Any prior DUIs?
No prior DWI, Judge.
Valid license?
Valid license.
All right, Mr. Finn, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, your bond will be revoked. You will go into custody. No more PR bonds. Do you understand?
Yes, sir.
Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them, and they'll tell you if and when you have to come back to court. If they tell me they can't get a hold of you because you're ducking and dodging, I will issue a warrant for your arrest. Just keep my city safe. That's all I want. You understand?
Yes, sir.
I'll have you sign a receipt with Victoria. We'll have you get with Fleischer for your bond conditions, and then you're free to go.
Thank you, Your Honor. Good morning, Your Honor.
It's not a good morning. No. You are using my name on an occupational license, and you're not in compliance with what you're supposed to be doing. It's unacceptable. If I find that it happens again, I'm going to yank it. I want to make sure that you're not using while my name is on the license. Do you understand?
Yes, sir.
I'm sending you now for a drug test. I want to make sure that you're not using, and then I don't know what I'm going to do. The first thing I want to send you for a drug test to make sure, and then we'll go from there. So we'll send you, and then we'll have you come back.
Yes, sir.
This is who, Judge?
No, don't worry about it. I'll have
Okay,
Victoria.
thank you.
Thank you.
Brad,
Oh, okay, got it.
you waved.
Okay. Yeah, okay. Mr. Beadle. Hey,
William Jones, you wanted us to come to docket today, and he's here.
I'd like to send him for a drug test, alcohol test. I want to make sure he's not using though.
If that's the court's prerogative, that's fine. However, he is checking into the Menninger Clinic tomorrow after his rehab from Ohio.
How long has he been?
And I'll be very frank with you, the last time I was here with him, he looks like $1 million compared to the last time I saw him. And I've been speaking with him very frequently on the phone. I'm more than happy for you to talk to him, Judge, frankly.
Come up, sir. The last name is, this is Jones.
William Jones.
We're here because Mr. Jones doesn't have his interlock that he was required to, and he's been out in lockout for quite some time,
Correct.
which is unacceptable. Right? If you're in rehab, we have to know, and there are certain measures that we can take, but just if you don't tell us anything and you're just in lockout, that's a problem. I have a real big problem, and I don't know you. Everybody tells me it's little raindrops and gumdrops and little bunnies jumping in the woods, but how the hell do I know? So he's telling me that you've been in a rehab in Ohio.
Sir.
When?
The last setting that we were here, the prior setting to this, Judge, he got on a plane from the courtroom and went off to Ohio. And I actually forwarded the court his admission paperwork to that facility in Ohio.
What was the date of release from that program?
It was last Friday. I spent 8 days in the hospital detoxing, and then the rest of the time in the rehab. And, I'm trying to put together a forward plan. I'm not supposed to be talking too much, but to take aftercare and go back to another rehab here locally and work on getting better. And I'm being proactive with that, Your Honor. He's had to change insurance.
That's all we ask, because the problem is that some people can, and some people can't,
Sure.
addiction, it's a lifelong and it's a persistent monkey that's on your back that will never let go. It will constantly grab at you. So if you're not proactive about it, that's when it grabs you by the boo-boo and it just doesn't go well.
Yes, sir.
I just need to make sure that you're not using, number one. Number two, most importantly, that my public is safe, because I certainly don't want you in a car unless, you know, everyone is protected. And the way we know that is that you don't have alcohol on board. So what I'm going to do now, because you've been so AWOL with regard to this, I'm now putting a monitor on your ankle so I know that you're not consuming. If it goes in lockout again, I will put you in jail. I want you to know that. I'm not going to do this again with you. Do you understand? You've been in lockout for a significant amount of time, and it's not fair, because I normally would put people in jail lickety-split for something like this. Do you understand?
Sure.
I will not play this game with you again. It is your responsibility to charge it on a daily basis. It is your responsibility to know what you are putting in your body, as far as, you know, whether it be mouthwash, hair dye, a tequila lollipop. I've heard it all, and I don't care for excuses. It is your responsibility to know. You've got such a great team of lawyers. There's just no excuse.
Sure.
I will waive the fee so that there's no excuse for, well, I can't pay for this. I can't. No. Do you understand?
Your Honor.
What you do on your time is you. As long as I know that you're not using, I'm happy. Do you understand?
Yes, sir.
Okay.
I'll be happy once he checks into the medical point. You alert the DAs, the court. Everybody.
Yeah, I guess
There.
we're going to give him the scram device today. Just keep us in the loop as far as the cases are too terribly old. You know, it's not old. So just keep us in the loop of when he's released. Just, you have to calibrate this thing on, I think it's monthly. So make sure that you calibrate this thing like it's supposed to. They have to download it. You've got to charge it. So make sure you know of everything you can and can't do. You understand, Mr. Jones?
Yes, sir.
If I have you come up here on another violation, it's probably not going to go well, just so you know. Okay? Okay, guys.
Understood. Thank you.
Can he
Got it.
be released from the jury box? Just take a seat. We'll get you.
Would you like to-
Morning, Mr. Rojas.
Morning.
So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. As you, I don't know if you know, but your lawyer's here with you, but he's on Zoom. Just, it's not here in person. Okay.
On February 22nd, 2025, an officer was dispatched to a major crash call involving the defendant striking a parked vehicle in the Concord at Gulfgate apartment complex. The Houston Fire Department observed the defendant asleep behind the driver's seat. The officers observed the defendant to exhibit bloodshot eyes, slurred speech, and a strong odor of alcohol upon his breath and slow movements. SFSTs were conducted. 4 out of 6 clues observed on the HGN, 4 out of 8 clues observed on the walk-in turn, and 3 out of 4 clues observed on the one-night stand. The defendant consented to a breath test, and the results were 0.125 and 0.121.
Okay. Any prior DUIs and a valid license? Mr. Rojas, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will put you in jail. No more PR bonds. Do you understand?
Sure.
His driver's license is eligible.
As long as you have a valid Texas driver license and liability insurance, then you may drive. If you do not have liability insurance, car insurance, you are not allowed to drive. That is also a condition of your bond. Do you understand? Because you have a lawyer, I will waive your appearance. You do not have to come to court until your lawyer tells you to. So you must stay in contact with him. If he tells me he can't get a hold of you because you're playing games, you're not responding to phone calls, text messages, I will issue a warrant for your arrest. Don't consume alcohol, don't consume drugs, and don't be a danger to my community. Do you understand? I will have you sign a reset with Victoria. You will get with Fleischer for your bond conditions, and after that, you'll be free to go, sir.
Mr. April 29th through May 1st.
April 29th through May 1st, Michael.
April 29th. Thank you, Your Honor.
Okay, cheers.
Have a good weekend, Your Honor. Bye-bye.
Have fun. Mr. Madrid.
Yeah, good morning, Your Honor. I've got a case on Monday at Christopher Torres.
Okay.
I had emailed your coordinator earlier and to give her kind of a
Is it an
heads up.
arraignment?
No, we were hoping to possibly plea. We had done a PSI 2 weeks ago because we were going without an agreed rec. I'm not in trial today, but I've been in trial for the last week on a capital murder trial. We don't have trial today, but we resume on Monday, and I think it's going through Wednesday. So I was requesting if we could move it till Thursday, if possible.
Yeah, of course. I mean, if you're in trial, you know.
Okay.
What's your cause number?
Let me.
You got it?
It's 2522707.
At the last.
So you said you did a PSI on which one? On this case? On something with him or with?
I'm sorry. I'm getting confused with what I'm doing here. We did a TRAS.
Got it.
And we were going to go without an agreed rec. We approached you last time, but you said, well, let's do a TRAS and then we'll talk about it.
Okay. All right. Yeah, let's, I'm okay with setting it for Thursday morning.
Okay. Thank you very much, Your Honor.
Yeah, for sure. We got you.
Okay. Have a good weekend.
Thursday.
Thursday the 6th.
The 6th, right?
The 6th, yes.
Okay, cheers.
Thank you so much, Your Honor. Have a good
For sure.
weekend.
Good luck.
Thanks. Goodbye.
What are you doing with yourself these days?
I am.
You in TSU?
Yes, I am a property manager. I'm in grad school getting a master's in counseling, and previously
Great.
I was an adjunct professor last semester.
Fantastic. Well, that's great. You're doing great. You know, just, we all fall down, you know, we all make mistakes, but the idea is that just no more, right? Especially when it endangers other people, right? Don't say anything. No, don't. Just, you're doing great. Why mess it up? You know what I mean? You're doing really good. So we're not going to do anything with you now. We'll let you keep going. Just don't forget to blow anymore. If it happens again, I'm going to yank it. You understand? No, now's not the time, because the problem is that I don't want you to say something that hurts you. You know what I mean? You've got a license. There's requirements with the license for you to have it. If you don't fulfill those requirements, I can't keep the license, you know?
Received.
Okay. I'll let you speak with Shatoria, and then Shatoria can always, you know, kind of be the in between, okay? If there's any issue.
Is there anything that's available that can be released other than the dues?
I did your rip con,
Oh, yeah, I saw the rip in there, but
but
no.
nothing else.
Okay.
Can I talk to him real quick while we're waiting on your guy? Mr. Tyson, hey, are you ready?
I have a question, Your Honor.
Shoot.
On DWI, we are trying to work out an offer deal with the state, possibly a time served.
It's not a second, right?
No, it's just,
I'm happy to do whatever you guys want to do.
okay, well, my question is, will you run the driver's license suspension concurrent with the DPS? No? Okay. I'm just asking, gotta ask, gotta let my client know.
I run jokes concurrent, but this license, hell, she has literally been.
I understand, Your Honor. How about the surcharges?
Reward people when they deserve it, you know, but here,
Oh, okay. Yeah, since there was something not good happening, or that happened, what about surcharges?
of course,
Okay.
that's what I'm saying.
All right.
That, yes, license.
Gotcha. I understand. Thanks, Your Honor.
Yeah, of course, Mr. Tyson. Coming up, Mr. Lopez. Yet another terroristic threat. Let's go through your criminal history, Mr. Lopez. 2012, burglary habitation. 15, assault, bodily injury. 15, criminal mischief. 20, criminal mischief. 16, criminal mischief. 17, suspended license. 18, interference with emergency request for assistance. 22, kidnapping. 24, aggravated assault of a family member. Terroristic threat, evading arrest, terroristic threat, and now another terrorist. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Please.
On February 25th, 2025, officers were dispatched to a residence at 2715 Owen Cross Drive in Harris County, Texas. The complainant stated that in the first week of February, the defendant snuck into the residence via the garage door, and that she had been telling the defendant that he does not live at the residence and has to leave the location, but the defendant refuses to leave. The complainant, who's the mom, has been saying with the complainant two, the daughter, or the complainant one's daughter, the defendant's sister, at a different location because they fear the defendant. On 2/25, the daughter came to the location.
Oh, and here comes one of the heaviest moments in the docket. This judge is laying it out raw. This defendant is what the system calls a true habitual. Multiple serious charges stacked over the years, so another violent felony could mean 25 to life. Judges don't say that lightly. This is where the stakes skyrocket. Audience question: do you think tough warnings like this help someone turn their life around, or do they just push them further into panic?
Retrieve the dog. The complainants had a verbal altercation about the dog being missing and the defendant wanting money from them. The defendant then threatened to harm both complainants, saying, "I'm going to beat the shit out of y'all. All y'all do is send me to jail. I'm going to beat y'all's ass up. I'm going to beat you up." The complainants advised that they are fearful for their lives due to the defendant's threats and his history of violence.
So we do have a history of violence where there are threats and aggravated assault against this family.
Yes, sir.
Mr. Lopez, they are terrified of you. The thing that you also need to consider is that you are a true habitual. So if you pick up a very serious felony, you could be very well looking at 25 to life. You know what I mean? 25 to life. You pick up a serious case. These are the things that you need to think about when they're out there in the free world. Do you understand?
Sir.
I don't want you going within 1,000 feet of where they live or where they work. You will get a GPS monitor if you are able to bond out. I don't know. At this point, you have not made bond, so I don't know if you're going to get out. But if you do, you must have a monitor on you, and I don't want you to go anywhere near where they live, where they work, where they breathe, where they put their head down, and you're not to be in possession of any weapons. Do you understand?
Yes, I do.
You know, I would venture a guess that probably 98% of the people that are in Harris County Jail, and I don't know if I've told you this before, but are there because they have absolutely no self-control. They get upset and they wig out without thinking, if I say this, what's going to happen? If I do this, what's going to happen? This is what you should be thinking about every time you're out there. Do you understand? It's not hard. Really. You're also not to consume alcohol or illegal drugs, and I'm going to randomly test you. So counsel, at this point, he's not made bond. We can just set you out for a couple weeks, wait for the evidence to come in. If he does get out, he needs to be here the next business day for all the conditions. And then I definitely want a GPS prior to release.
Mr. Your Honor.
Okay? Self-control. Okay, thanks.
Thank you, Judge.
All right, thank you. Good morning, Mr. Johnson.
Good morning.
Mr. Johnson, you're charged with terroristic threat of a family or a household member. That kicks it up to a Class A misdemeanor, so you're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement where they're offering you 150 days in jail with credit for the 53 days that you've done. You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers, If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this agreement, you can never change this or undo this. Is this what you want to do?
Sir,
How do you plead to the office, sir?
guilty.
I'm going to find you guilty and we'll follow the agreement, send you to 150 credit for the 53 days that you've done. Good luck to you, sir. Thank you.
Judge, we are approaching to deal with the BVR on Miss Danielle Free. I think it was last Friday or maybe the Friday
Free,
before
come up.
last, Judge. She missed it because she was out of town. She got the notice on a Thursday. She couldn't get back. She did try to go to pretrials to get it done, but they couldn't get it done.
Do the order now.
Oh, I know, but she did one this morning and she's negative. So,
Don't let it happen again.
Yes, sir.
If it happens again, I will issue one for your arrest. You're on notice now. No tolerance from this day forward.
Okay, thank you.
she's PTI bound anyways, Judge, so we're just gonna.
Thanks,
Thank
man.
you.
Of course.
Judge, I just got appointed to Mr. Wyckoff this morning, and I was told I need to approach because he picked up a felony. He's in custody, Judge.
Did he make it up today?
Make it up today?
Back then?
Let me check, Judge, but I just wanted to see if we wanted to keep his bond the same, or
Oh, yeah. We've got a lot of,
I think his bond's set at 15,000 right now.
yeah, we can't get him here. It's just,